David Dornbos, Littleton, Colorado. David Dornbos, Littleton, Colorado.
All right, I think we might have everybody back. So, welcome everybody to actually our 85th meeting of the Denver Association of Assisted Living Residences. Yeah, I know, isn't that crazy, Brian? So let me go ahead and get rolling with tonight. So can everybody see my screen that I'm sharing? Awesome. Now if I can find my other screen, get me going here. All right, so we just went through all the networking information. Usually I try to say this on the front side. I always like to pay homage to Gene. Gene is, he was instrumental in the founding of the RAL Academy, the RAL National Association, and introduced thousands of people to the model of residential style assisted living. His motto was do good and do well. And Gene's the one that got me involved with this assisted living. So unfortunately, we lost him a few years ago, but I always like to remember him when we do our meetings because he was really a pillar of our community. Next, I want to talk a little bit about our website. That is the DAALR.com. And if you are in Colorado, this is very important to you. We have some links on here. They're basically shortcuts to what's in the state regs, and we just made it easier for you to find those. Probably the most important are these two links right here, which are right at the top. And this is the chapter 7. These are the new regulations, and chapter 2. So if you're getting started, or even if you're up and running and haven't looked at these lately, you should probably peruse them and just see what the regulations say. If you're an administrator, you really need to know these like the back of your hand. We always invite everybody to join our Facebook page. That is Denver ALR. This is our community. So we want you to be a part of that community, and that's what the social media is all about. Also, we want to thank everybody for signing up on Meetup. And we ask that at the, if you get prompted for a review, that you give us 5-star reviews if you can. If not, let me know why and what can we do to improve. You know, we're always interested in what the feedback is. What can we do? If you're looking for something that we can present as a topic, then go ahead and put it in there. We certainly want your feedback. So next, I want to talk a little bit about our sponsors. Without our sponsors, we could not do this. So I'm going to go ahead and make a run through, and we'll start with Hall Ryan Construction. With 35 years of combined construction experience, the exceptional team at Hall Ryan Construction has transformed residential and commercial properties by bringing a high-touch, customer-centric approach to every engagement. On the insurance side, Hall Ryan's reconstruction and roofing experience is a skill that many insurance companies actively seek out. Their reliance on Hall Ryan's experience is helping them write estimates that made Hall Ryan a well-respected and trusted expert in this field. And next, we would like to talk about Palm University. And Brett Chakavis has put together a really nice program for a high-end 16-bed model. Also on his website is a great collection of training videos, mostly geared to the experienced operators. So if you're in this business and want to learn a little bit more about how to operate, navigate to palm.university to get more information. Also, we want to talk about the RAL National Association. Brian, would you like to say a few words about the RAL National Association?
Yeah, sure. Well, we can start with every month. There is a meetup group meeting, and where we get to talk about a whole lot of things, including some interesting services that are available. I usually give an introductory presentation on some important either market or legislative things that are going on that I bring to the members' attention each month. It's a huge organization with over 27,000 members, and if you're going to be in the assisted living business, you should be a part of that. Yeah, and it happens roughly the third week of, well, you can get the information here at ralna.com and sign up for the meetup groups there. Thank you.
Thanks, Brian. Okay, next we're going to talk about the RAL Academy. So if you are new in this business, this is probably the best place to go just to get your feet wet and learn a little bit about this business. So if you go to ralacademy.com, you can sign up there. They've got a few different courses. They have an online course. They've got a basic training course. What's that?
Oh, they're working at computer technical stuff.
Oh, okay.
Hey,
And
Brent.
they also have some,
This is the sponsors session.
they
Hey,
have,
Brent.
yes, somebody trying to
I
holler.
think, I think on your Facebook page, I think
Provide a
somebody's
picture.
using it. Somebody's using your Facebook page to send out nude photos. So I've just realized that.
Well, let's not let that happen.
I don't know.
I don't
Yeah.
know
Different
how-
real estate. Different real estate. Well, let me, if you don't mind, Vern, I'd like to say something about the academy.
Yes,
I will
please.
tell you, you'll hear from us shortly. We're lawyers in the assisted living business, and as far as I can tell, we're the only lawyers who do this. And the academy, what we see is the people who struggle the most have not done anything with the academy. The people who do the next best are the ones who've done the online course, and the ones who tend to do the best, increasingly best, are the ones who've done the in-person 3-day event and then on to the platinum package. So this organization definitely helps prepare people for this business from the business side. It's a really good organization.
Thanks,
Vern.
Brian. Okay, so next we have assisted living marketing, and we happen to have the esteemed Peter Brissett here to talk about assisted living marketing.
What's happening? Esteemed. Wow, that was very nice. Yeah. I'm esteemed, not steamed, but esteemed. So quite content. Yeah, we do digital marketing mostly, website design. We will do graphic design. So if you need a logo or something like that, you need print, you need business cards or brochures. We can help you with that. We can help you with content, any of that stuff to help market your location, help you with reviews and SEO and all that good stuff. That's what we do. Been doing that for senior care assisted living for 14 years. So we learned a thing or two about it, and happy to help or answer any questions that you have.
Terrific. Thanks, Peter. And to visit his site, that is assistedlivingmarketing.com. Our next sponsor is actually our speaker tonight, and that is Janet, and with Senior Care Administrator Coaching. Janet, do you want to say a little bit about your business?
Yeah, you know what? I was an administrator for 14 years. I ran 8 group homes kind of around the Denver metro area. I left there in 2021 and decided to open up my own consulting business. I help other people learn how to run their business. Sometimes people make it more difficult than it should be. I did that for like 3 years, felt like I was running in a gerbil wheel. I did what I call reactionary management, where I ran around and put out the next fire. That's not fun. So now I do consulting. I teach the 40-hour administrator class. I am teaching a 10-hour bridge class for all of you that have anybody that has a 30-hour administrator certificate. You have until June 30th to get an additional 10 hours. After June 30th, you will have to get the 40 hours. Your 30-hour certificate will be dissolved after June 30th. So anyway, I teach, I come on site, I do some mock surveys for some places. I think a mock survey is like a scavenger hunt. I actually think they're so much fun. I try to find out what you're doing that is not according to regs. It's a fun process. It's not a shaming process. It's fun. We look for, and I show you, I have forms on my website that show you, you know, things that you might want to use in your home. So, but yeah, my name is Janet Cornell and I'm with Senior Care Administrator Coaching.
Thanks, Janet. And you can see her website, scac-janet.com. Our next sponsor is the investment community of the Rockies. ICOR is Colorado's only nationally recognized and award-winning real estate investors association, serving Denver Metro, Colorado Springs, Fort Collins, and Northern Colorado, as well as real estate and rental property investors across the state. I've been a part of ICOR since 2013, so gosh, 11 years. They're a great group to be a part of if you're a real estate investor, and I highly recommend going to icorockies.com. And our next sponsor is Colorado Assisted Living Lawyers, Pinkowski Law, and we have Brian Pinkowski.
Hey, how about that? Yeah, I would say we probably are more than Colorado, but Colorado is near and dear to us by far. Yeah, so we do everything on the legal side from assisted living, from helping you find the right location from a legal standpoint. Vern, of course, helps you with the real estate and help you find. We make sure that the real estate works for the number of beds in your business model. We help you get through your purchases of the business if you're buying an existing place, as well as resident agreements, other kinds of legal contracts that you might need to have. We help people with regulations and regulatory problems quite a lot. And then we help people with the other side of the life cycle, which is with the sale of the property, or now we're also helping people with receiverships, if that ends up being the case. So the entire life cycle of the assisted living business, we help with all those legal matters. And
Thanks,
we
Brian.
love being part of Vern's group.
I've worked with Brian and Michelle for many, many years now, and we recommend them to all of our clients. So they are a great resource for you. And next, I'm going to talk a little bit about A Better Way Funding. This is the group that I work with. We do lease options for group homes, and you can look up to see what that program looks like on ralleaseoptions.com. And another part of our group is the Grand Avenue Business Brokers. This is my particular company, and I hang my license at A Better Way Realty. I've got over 30 years of business experience. Have done over 60 assisted living transactions worth more than $100 million. I am a certified business intermediary, and obviously my specialty is assisted living. Let's see, we've done some deals lately, but you know what? I'm a little behind on getting this up and running. We still have 55 beds out in Eastern Colorado and 16 beds in North Metro, and our ABW funding program is available for that. We closed 3 8-beds. That was a little while ago. We do have 12 beds northwest of Denver. We closed 56 beds. That was about 2 months ago. The 46 beds in northwest Denver were closing on Friday, and we did close 8 beds on the western slope, and we're getting ready to go under contract on 118 beds in Arizona. So we've been a little busy, but always looking to do more. So if you need help buying or selling, please give me a call. My cell number's right there, and I'll put my contact info in the chat as well. Next, we have news from CALA.
Okay. Yep, news from CALA, Colorado. CALA is Colorado Assisted Living Association. We primarily are the association for smaller companies of 50 and under, but we have now kind of morphed and have some bigger associations too. Our big news is that our bill was introduced to the Senate floor. I think it was Friday or Monday. We have established a bill to make it easier to get employees up and running. We want their certificate of training to be portable from one employer to the next. So as you know, you have to jump through about 5 or 6 hoops, and sometimes it has to be rewritten and it gets morphed. And so, you know what, it's still in the infancy stages, but it has been introduced to the Senate floor as our brag for today.
Nice work, Janet. And while we have Janet, let's go ahead and introduce Janet as our speaker tonight. And she's already introduced herself, but she's going to talk a little bit about the new assisted living regulations that were passed effective in January 24. So I'm going to turn the screen over to Janet, and Janet, you have the floor.
Okay. Yep, let me do full screen here so I can All right, let me back up the train a little bit. In 2022 was not an awesome year for the legislators versus the assisted living industry. Everybody jumped in and filed bills that directly affect the way that we can operate in Colorado. So two of the bills aren't too bad, and then one was kind of horrific. So we'll be going through those bills tonight. I will start with the easiest. When you have a bill that's passed, it goes through several stages. It goes to like 5 different committees, and then the governor, it gets voted on, and then it gets passed to the governor's desk. Once the governor signs it, it becomes law, which then we have to morph the law into regulations. Sometimes senators write these so tightly that you can't get around them. They have passed this all the way through. That's been the result of the two that are the most awful, is we didn't have any wiggle room to write it in a way that it was actually, you know, palatable for our industry. I did sit on the rewrite team to help rewrite the regulations, and we fought as much as we could to make these good for assisted living. I'm not sure we accomplished much in that regard, though. If you're ever asked to testify for assisted living, I hope you show up. The more, the better. The more voices we get from our industry, the better. So if you ever get an email from someone that says, we need you, we do need you. Here we go. Everybody can see that now? All right. I think it's going to let me. Nope, it's not letting me do a slideshow here. Nope, might not be able to do the slideshow. Well, we might just have to do it this way. Can everybody see this? It's not allowing me to go to slideshow for some reason.
It works for me.
Yep, I can
Okay.
see it.
Okay. The new regulations actually were adopted November 15th of 2023. So when you see this, that's why you see it, is it was 2023. It's presented by me. It's still your responsibility to read the regulations. I'm just interpreting the best that I know how. And sometimes the regs are not exactly black and white. They leave some stuff to be interpreted. So we had 3 bills that were passed in 2022. We spent an entire year rewriting the regulations to fulfill these obligations. One was Senate Bill 2253. One was Senate Bill 22079. It has to do with dementia training. And the awful one was Senate Bill 22154, which was titled Safety in Assisted Living. And that is a, what do they call, sheep and wolf clothing? That is not making us safer. Senate Bill 2253 is not that bad. It has to do with visitation rights. Family and friends of members and guardians in any healthcare setting, assisted living, hospice, rehab centers, hospitals, anywhere. The facility can no longer restrict the right to visit if we're in a pandemic. They can no longer restrict the visitation if their facility is in outbreak. So visitation has to be allowed all the time. You can no longer restrict visitation unless some reason there's a big federal mandate. I was actually in favor of this. I do not think that it was fair for our seniors in assisted living to have all of their visitors withheld. There was a lot of sadness in assisted living through that time. I don't think we needed to have 50 people over, but I think you know, there needed to be some visitation. So you no longer can restrict visitation at any time for any pandemic or any outbreak in your own facility.
Yeah. Nothing we need to do. We never restrict.
Oops, it's not doing it right. Okay, you have to update your written policies and procedures to reflect this. The residents can require visitors to wear PPE and enter through a specific door. So you can write your own guidelines about what your visitors you want them to do. Do you want them to be screened? Do you want them to wear a mask? But you just can't restrict them. Your residents' rights are different. They must include the right for each resident to have at least one visitor of choice. And your care plan has to be updated to identify all of your external service providers that are allowed to visit for that resident. So let's back up a minute. That one's not scary. It's you know, visitation rights. That one's not the big deal. The next one that was passed was Senate Bill 2279. This is dementia training required for all assisted living facilities. It used to only be facilities that specialized in dementia care, like the secure dementia care, but it is all assisted livings. If you're running a brain injury home, mental health home, it's everybody has to allow, they have to do 4 hours of additional training and 2 hours every 2 years. Well, that's really out of sync with what the rest of the regs say. So I say if you're running a home, do an hour every year and you meet this regulation. Your new staff must be trained within 120 days. And your existing staff have till April 30th to get this 4 hours of training done. And it's not just any training. The senator that wrote this put specifics on it. If you're running a secured dementia home, you're already compliant with this regulation. Like Fran, you're already compliant with this. You're running secure homes, you're already compliant probably.
Janet, do you have resources for where they can get that training?
You know who did this is Leading Age of Colorado. They provide an online training and they charge you a one-time fee. Whatever their member fee is, if you're not a member, they'll charge you double. But I looked it up the other day for a 70-bed facility. It was $200 for all of their employees. So
Wow.
a small bed is like $100. It's like $50 for if you're a member. It's expensive to join Leading Age. Leading Age usually attracts the bigger facilities. Leading Age is a national company. It's not just a Colorado either. So Leading Age has graciously shared their site with us. The training must come from recognized experts. So you cannot do your own training because you're not a recognized expert. It comes from agencies, academic institutions that specialize in dementia care. Whoever's teaching it has to have 2 or more years of experience working with people living with dementia.
I think that I know that there are some smaller homes that specialize in dementia. I mean, they provide dementia training, so I'll look it up and put it in the chat.
Yeah, and if you're like there's one gal that has she's TPS Snow trained or whatever, she is able to do that. Yeah, so there's some of them.
I am
Audrey.
too, but I still
Audrey,
don't want to train.
Audrey, do you know anybody that could go to the homes and train them? That would be great too.
I'll put it in the chat. I don't know if they will go to the homes, but I know that they do dementia training.
Yeah.
Okay.
Okay.
The training must be documented in the employee file. You can't just check the box that you did the dementia training. The certificate has to be in the file. It has to cover these topics. This was written into the bill. Dementia diseases and related disabilities. These are things like Parkinson's dementia, Lewy bodies dementia. Everybody says Alzheimer's, but it's not all the time Alzheimer's. You can get dementia from a brain injury. You can get Lewy bodies, Parkinson's, all of those fall under that. It's person-centered care of residents with dementia. It's care planning for residents with dementia. It's activities of daily living for residents living with dementia. And it's dementia-related behaviors and how you communicate with these. So it has to cover those 5 things. The senator that wrote the bill put those in there. It got pushed all the way down the line. So these 5 topics are actually in regulation. So you have to have that. There are some provisions that if your staff was recently trained, they may be exempt from more training. Good luck reading that to see if your staff are exempt. It's like a page and a half and it repeats itself and it's just the craziest thing I've ever seen. So I think it's just easier to train your staff than to figure out if they're compliant. The documentation that's in their file has to include the date of the training, the hours, the name of the instructor, and the training entity. CDPHE says they'll be offering this training through CoTrain at some point in time, but they have not yet. So when you hire somebody new, they have to have 4 hours. And your existing staff have to have 4 hours. And then you have to offer 2 years or 2 hours every 2 years. Okay, so anyway, that one is not that hard. Just train your staff. It's not that hard. Just find somebody, train your staff, and it'll be done. Just make sure that they're approved through, with what they need to do to be able to provide that. Here's the big one, safety and assisted living. It has 3 parts to it. It's administrator training. They want all administrators to have 40 hours of training. So the 30-hour certificate has to have 10 additional hours. It includes the right to challenge an involuntary discharge. Anytime the facility initiates the discharge, it's considered involuntary. So it's the resident or their family have the right to challenge any discharge. And the other scary thing is fines for deficiencies are no longer capped at $2,000 per calendar year. That is the old regs. They can be as high, oops, I have a typo, high as $10,000 per violation or more, depending if the violation was considered egregious. The one that decides if the violation was egregious is the state health department. So does anybody need me to go over that again? There's no longer a cap on that.
10,000 or more.
Or 10,000 or more per violation.
So you're saying that even if they show up and then like you have few, maybe 1 or 2, minor attacks, it's gonna start
I
from
got
10?
that in here. I got that in there. What's a minor tag? Because that makes it scary. Yeah.
Okay.
So can we ask about the first point?
Yes.
So are you saying, or are they saying that an administrator that's been an administrator for 10 years now has to go back and get 10 more hours?
Yep, exactly. By June 30th. Everybody
Okay.
that has that 30-hour certificate has been an administrator for a long time and probably knows their business. Steve Cox wanted it that you had to go back and repeat the entire 40 hours.
Where is that training available?
You know what? CALA does it. Colorado Assisted Living Association does it. And so you can go there. I don't know if CHCA is offering it. I heard some rumors they were, but they're kind of for the bigger places. So CALA is doing it though.
I think senior care too. Yeah.
Senior care.
Yeah.
Who's senior care?
I forgot the other name.
Leading age, I don't know that they are doing it. It has to be an association that does it or somebody that's approved to do it. The 10 hours is not.
I think Margaret Ray's old place does it too.
Oh, you know what? Christy teaches it through CHCA. Yes.
And Eileen, what's her name?
She's doing the bridge class too.
Yeah.
Yeah. So there's a couple so you got some options. So that's good.
And you're doing it too, is that
And
correct?
I teach the bridge class for CALA. Yeah.
Okay.
I cannot do it by myself anymore. You have to go through an association to teach stuff now. So the first one is administrators. They have to have 40 hours. They have to take an additional 10 hours. So check your certificate. That's the only way that you know that you have 30 or 40 hours. Typically, if you got your administrator certificate before 2018, it's likely you have the 30-hour. So you have to get that done by July or June 30th. So that's not that bad. I don't think that part of the regulation was bad. It's just get the extra 10 hours. I think it was stupid, but I still think it's not that bad. The program has to be taught by an accredited college, university, vocational school, organization, association, or group that specializes in residential care services. The approved training are the same as the previous regulations. So who could, teach this obviously is the same as the administrator's class. CALA is an approved provider under association status. They have specific topics that have to be covered: administrator duties, regulatory updates, and best practices. You do have to have documentation in your file that you've completed these 10 hours. The document or the certificate must include the date of the class, the length of the class, and the instructor's name. So that's what they've left us with. Any questions so far? No, that's pretty easy. Yeah, that's not that hard. Okay, also added to the regulation is there's $1,000 fine for any facility that's operating without an administrator or without an interim administrator. And your facility has 24 hours to notify the department of an interim administrator appointment. So if your administrator does a walkout, you got 24 hours to tell them who's the interim administrator, or they will fine you $1,000. If they come on location and their site says that Betty's the administrator and they come on location, you have not filed the correct information for change of administrator. So you could in fact get that fine. I'm not sure if you do. So your interim administrator must complete the 40 hours of training within 30 days of being appointed. And they have to have a fingerprint-based background check within 10 days of appointment. And they have to have a CAPS check at time of appointment. These are copied right out of the regs. So if you're promoting one of your existing staff, I read this, that you better do a CAPS check at time of appointment. Anybody else want to chime in on that?
What is a CAPS check?
It's a Colorado Adult Protection Services check. It shows you if anybody's currently in the court systems that may have done something stupid. So they don't show up as a background issue yet because they've not been, Brian can use the right word, convicted of it. It's still in the legal system right now. But if you promote one of your staff, then I would do a CAPS check as soon as you appoint them.
What if you became an administrator before they did the caps?
You still have to have a, you know what? I still think you have to have a CAPS check.
Yes.
Yeah.
So you're saying also background check, regular background check is not valid anymore for the interims?
No, you have to do both for your existing staff. You have to do both for staff. You have to do a background, you have to do a CAPS check plus a CBI. You have to do
CBI is
both.
a fingerprint for the interim or just the CBI as well?
No, the interim administrator has to have a fingerprint background check.
Okay.
So Fran, if you leave abruptly, you have to have, like if you quit and sell your business and run away, your next person has to have a background check or a fingerprint background check. So, that's not that hard. I don't think that's that hard. So now we're going to get into the meat of the program, the challenging an involuntary discharge. An involuntary discharge is considered any discharge initiated by the assisted living home. By definition, if you don't take somebody back from the hospital, you have initiated a discharge and that person can challenge it. So I would probably write a discharge notice if you're not going to take somebody back from the hospital, because they can challenge that and everything has to be documented. Even if they're at the rehab center, they can challenge it. If you cannot take them back from rehab, they can challenge your discharge. In the good old days, you just went to the hospital and said, sorry, they're above our head, then they would find places for them. And that was the end of that, but they can challenge that now.
So in the small assisted living homes, like, we know that it's assisted living home, it's not skilled care. So, they will know, we will know, but if I go in and assist somebody and she's no longer like that anymore. So, if they let me, or if they're challenged and if I allow them to come back, I will not have the skills to take care of them. In that case,
It doesn't mean you have to take them back. It means they can still challenge the discharge.
If I can add to that, Janet?
Yeah, please do.
So, technically, the challenge is worded as a grievance. They can file a grievance. And you have to respond with the reasons for that, but that doesn't mean that you have to take them back until the state issues some kind of a final decision. On
They do
reasons
list
for
it in regs as a challenge. They do list it specifically in regs as a challenge. That's why I'm using that word, because it gets dicey. And then there's a right to an appeal that, so I'll get to that, but it's, yeah.
Thank you.
Okay, the assisted living residence has, or the resident, the person has the right to challenge the discharge within 14 days of being served the written notice of discharge, regardless of whether or not the resident has already been removed from the assisted living residence. So if somebody is in the hospital and you cannot take them back, they are not in the facility, but they still have the right to challenge the discharge. They have 14 days after you've served them some type of notice to challenge that discharge. If you wait till the last day they're in the hospital to issue that notice, they can challenge it up to 14 days. That doesn't mean you have to take them back. It means that they can still challenge that. Every person that lives in assisted living now has the right to designate individuals. Notice there's an S on that. Individuals to be notified in cases of emergency or involuntary discharge. These people don't necessarily have to be the resident's legal responsible party. It's anyone the resident designates. The notice of discharge has to go to all of the people they listed. This is probably not that hard for senior care because they have a family. When you're getting into the mental health arena and they can list 50 people on here if they want. You got to notify all 50 of them. I don't know of anybody that's done that, but technically, if they list 10 people they want notified in case you have to discharge them, you have to notify all 10. So before we go on, does that make sense to everybody? The resident themselves has 14 days to challenge the discharge. So therefore, your discharges are in writing. Yeah.
This is Wendell. So does that mean that I need to go back in and revamp my admin papers with them to give them a list to list?
Yep,
Because
we're
right
getting into
now,
that. You have paperwork that has to be updated to meet this.
Okay.
Yeah, we'll be getting into that. Then let's say the resident decides to challenge the discharge. The facility has 5 days to respond to that discharge, and your response has to be in writing. The ombudsman's gotten in the middle of this now, and when you discharge a resident, when you give them their written 30-day or their written notice, they want to see supporting documents of why you discharged them, what you did to try to avoid the discharge. They want to see all the supporting documents, the incident reports, the progress notes. They want to see the whole thing. And I may be jumping ahead of myself a little bit, but
Who is they? Who?
the ombudsman.
The ombudsman.
Yeah.
Okay.
So you have to give a detailed explanation for the reason or reasons you discharged the resident. You have to give all the facts or evidence supporting the reason given for the discharge. So if you're discharging them for 2 different reasons, you got to list all of the reasons for both. You have to give yes.
So if I discharge somebody right now and then tell them that you're no longer because of so and so and so. So for the first notice, they want us to attach all the documentation of what happened, or it's through with the appeal.
Yep. And no, that's not right when you discharge them. These have to be right with your discharge notice. You have to provide information on the recounting of events leading to the involuntary discharge. These are in the discharge notice. The written 30-day notice must include all of these. You have to include interactions with the resident over a period of time prior to the notice being served of the actions taken to avoid the discharge. Okay, so that's all of that stuff that has to be done.
What's that mean, actions taken to avoid the discharge?
That's what did you do? Yeah.
Excuse me, Jenny, I'm curious, and this is Audrey Krebs. Ombudsmen typically don't have a lot of authority. Typically, they're just the mediator in between the community and the residents. But this is giving them what would happen if you didn't do this?
They make you start over and do it.
Okay, but what authority does the ombudsman have? Would they submit it to public health that they're not following the regs?
Yep, they do, because I've
Okay.
already been in the middle of one. One guy didn't provide the supporting documents. The ombudsman went in there and says, "Where's the supporting documents?" He goes, "I don't have any." And they said, "Well, where's the incident reports? Where's the progress notes?" They went down some list. He goes, "I don't have those." He goes, "Well," and then by that time the ombudsman got to his facility, he had already issued the notice 6 days ago. They said, "We want you to reissue the notice. The clock starts over, and we want you to provide these supporting documents."
Okay, thank you.
It's not
Deanna, what about in the case where a resident is a danger to the self or others?
I know you're clicking ahead going, "Oh my God," I'm getting to that though.
Okay.
You're like, what? Who wrote this? Yeah.
And this is Wendell again. This is just information we're giving to the person that we're discharging. We're not,
And-
we're not calling anybody else and giving everybody else this information. We're
Yes,
giving it
you
to
are.
them.
Yes, you are. The 30-day
We
written
are?
notice has to go to the ombudsman, your local ombudsman. And it has to go to the state ombudsman. It has to go to the legal responsible party. And
Oh,
all of this
okay.
information has to go to every single person they listed as their person they want notified for discharge. Has to go to all those people. All of these documents have to go to everybody I listed. Yeah. So what does that tell you about your staff, Wendell? It says take good notes.
Exactly.
Yeah.
Yeah.
What does this also tell you about your admissions process? Everybody, including myself, has been like, well, I don't know if they fit in, but maybe I'll try and see if they fit in.
Right.
I'll offer a respite stay to see if they fit in. Respite stays can file a challenge discharge. So I think it tightens up your admission process. I think you really look at this and go, I don't know if this person fits in. I've taken people on a risk. When I testified against this, I gave them a little spiel about Hannah. Hannah was a 52-year-old early onset dementia. She used to play tennis. She's very active. She's still very strong. The bigger place discharged her because Hannah is now nonverbal. And when you hold her, she will hold your hand and she doesn't let go. And when you try to pull away, she grabs harder. She broke a person's hand. And a little frail old lady. So they couldn't figure out what to do with her. I went there and walked around with her. Sure enough, as soon as I tried to pull away, she grabs harder and she's got a grip on you. So I handed her an object. All I did was say, Hannah, can you hold this? And she said, or she didn't say anything. She's nonverbal. She held it and let go of my hand. So I thought, okay, this is interesting. So I walked around with Hannah for a little bit longer and I guessed that because Hannah's nonverbal, maybe she wasn't getting enough attention. And so we moved her into our homes. She lived there 6 years. Within 6 weeks of living there, the hand-holding went away. Because I guessed it right. She did not get enough attention at the big place. She didn't have any voice. So we guessed right. She lived there for 6 weeks and she died. I don't know. What would I do now, though? Audrey, you're in the business. What would you do now? Would you accept Hannah, knowing that she may be able to challenge the discharge?
No, absolutely not.
See,
I mean,
that's
I
where-
would, I would, what I do is I do a geriatric assessment looking at the social, emotional, and physical needs of an individual.
Yep. Yeah.
And from there, determine where the best fit is.
Yeah. Yeah.
Thank you,
would've-
Jen.
I would've-
Thank you
yeah, I
for
would've
doing
said-
what you did for
Yeah.
that person.
Yeah, yeah. So she lived with us for 6 years. She passed away at our homes and it all turned out fine, but I don't know what I would do now. So. Okay, this tells me you need to document and you need to document and you need to document. And what I think needs to be on the pre-assessment form is the pre-assessment form. I would add a statement that's signed or the legal responsibility signs it. I have, to the best of my knowledge, provided all information about the physical, emotional, and social needs of the resident listed to enable the residents, the facility, to prepare a care plan for this resident. I understand that if I have withheld any information about this resident, it may result in a discharge. This is documentation that you have done the best that you can as the administrator or whoever does the assessment, and people probably maybe not have been forthcoming to you. I don't know if this will, I think this will give who's ever giving you information reason to pause if they're hiding information. I think I would have something signed by the hospitals too, have their social worker or the discharge planner. How about you sign this for me? Because sometimes the discharge planner will tell you, oh yeah, she's a one-person transfer. Well, yeah, she's a one-person to transfer for a guy that weighs 210 and is 6 foot tall transferring her. She's not a one-person transfer from my 5'2" staff. So this is part of the documentation I would include, is this statement on your pre-assessment. What are the supporting documents? The supporting documents are anything that's noted with any information about the resident. It's incident reports, it's fall reports, it's progress notes, it's behavior notes, it's care planning meeting notes. It's anything that's written down that proves that you're justifiable in discharging the resident. But what happens when you have none of this? And I've discharged a resident before without any of this. I discharged a resident before because I didn't like their daughter. I was done with her. That's probably not going to work. She was causing so much havoc. I thought, can't we find a reason to get rid of her mom? And we did, but that's not going to work today because I have to have incident reports, fall reports, progress notes, and behavior notes. So what if you're unable to meet their care needs? Somebody just, yeah.
This is putting us in a tough situation because like I have a resident that is so physical and violent.
Mhm. We're getting to that. That's this screen. What if you're
Okay.
unable to meet their care needs? If an involuntary discharge is initiated due to a medical or physical condition resulting in a required level of care that cannot be treated with medications, there's your behaviors right there, or services routinely provided by the resident staff or external service providers, the notice must also include an assessment by the resident's applicable healthcare or behavioral health provider of the resident's current needs in relation to the resident's medical or physical condition. This does not mean if they're in the hospital, that you contacted their own primary doc to write this. The primary doc hasn't seen the person. You have to get this from PT or OT. If the person went into the hospital, had a stroke, and now they're not weight bearing, you have to get a notice from PT that they're no longer weight bearing. That suffices this documentation. If they go, like Fran has residents that shove each other and push somebody down, you have to get some supporting documents from their behavioral health provider that says they are aggressive. What if you have a behavioral person and they're aggressive and you haven't tried any other approaches to manage their behavior? You cannot discharge them. They want to see facts and figures and everything else that you tried to work with that person and keep them in your care community. So if you've got somebody throwing things, you need to start working with the physician right away to get some medications, or you need to start working on redirecting. Some people that have dementia, you cannot redirect them. They're just hard to redirect. So I don't know what you do in that circumstance other than not take them.
Yeah, I mean, I have a resident that is like being physical with staff and residents, and he hit she hit the staff resident 3 times in the
Did
knee.
you document it? Did your staff document it?
Yes.
Yeah.
So
I would document. Did you give them notes?
I gave them notice, and the son gets up and says, okay, complain or you appeal, saying that okay, I can't find any other home, so she can't find any other homes. But at the meantime, at the same time, like she's still staying in my home, and it's so dangerous. And the person that that is being hit, he or she, the POA is trying to press charges. So it's getting ugly and kind of dangerous, and I don't know what to do.
Well, that resident is considered a danger to self and others. When this
Right.
originally was written, we were guaranteed we would not, that family would not be able to challenge that discharge. And that's not necessarily true now. There's a gentleman that I'm working with, his resident got violent and pushed a lady down. So then they tried to work with him and redirect. He pushed a second lady down. And that lady
Right.
got hurt. So then they
Yep.
sent him out to the hospital. They were lucky enough that when they called the police, the gentleman hit the police officer. So they took him, and now he's in the hospital, and his discharge notice did not contain the language that the family has a right to challenge the discharge. The discharge notice has to include that information. You have to notify. So Fran, right now you're out of regulation. I'm fairly certain you probably didn't tell that family they have the right to challenge that discharge.
No.
Yep. And so the next time that guy hits somebody, you call the authorities and you get him in a hospital room. I would already give him a discharge notice right now. I would already start the process. You said you did, but you're going to have to back it up a little bit.
Okay.
Oh, let's go back because we're probably not done with that. The other steps to this is here's the steps they go. You provide the discharge notice. It doesn't necessarily have to be 30 days if you can't meet their care needs. So you initiate the discharge. The family or the resident or whoever has 14 days to challenge the discharge. You have 5 days to respond. If the family at that point in time is not satisfied with your response, they can file it with CDPHE for an appeal. And then then the CDPHE has to be involved at that particular point in time. They don't even know who's supposed to do this at CDPHE. I called Steve Cox and said, okay, everybody that we're gonna send it to you. If you know, if they want to appeal it, we're gonna send it to your email because we don't know who to send it to. So he did give us some bogus email they're supposed to send it to, but so then they can appeal it to the state health department. So the state health department can get involved and see if the discharge was warranted. That's gonna get ugly.
So when somebody files a challenge to a discharge.
Yeah.
Do you have to include that in the discharge notice?
The discharge notice came first. They didn't appeal it because you didn't serve it yet. The discharge notice came first.
No, I'm saying in the discharge notice, do you have to include that they are able to challenge this?
Yes, the right to challenge, yes.
And where to challenge it?
Where they challenge it to is somebody at your facility.
Okay.
You as the administrator need to designate somebody that is going to handle the discharges and the challenges.
Thank you.
Resident can actually give a verbal challenge. Their challenge does not have to be in writing. So do not allow that person to tell your housekeeper that I'm going to challenge that. Yeah, Audrey.
But Janet, when you're writing the policy, doesn't it have to outline the steps so the family knows exactly, because that was the question, and where they can go if they don't.
You know what? Let me stop sharing. I'm not sure if I can get back to this. Yeah, you know what? Let me stop sharing this real quick so I can share. Your families, you have to update your paperwork has to be updated right now. Your residence rights has to be updated with the right to challenge an involuntary discharge. That's right away. You have to do that. Okay, so that's one form that has to be updated. The other thing that has to be updated is your lease agreement or your resident agreement. It has to state all of the reasons that you could possibly discharge a resident for. Some of those are in Chapter 7, some are not. If you're a facility that doesn't take wheelchairs, you need to list that. And your lease agreement or your resident agreement has to state that the resident has the right to challenge any discharge. And then you have to write a policy, which is your admission and discharge policy, that actually states, and Audrey, you're probably in the regs. So this is in the admission and discharge part, it's in there. So you can look in there and they give you the verbiage for that policy and what has to be in the discharge part of it.
Okay, thank you.
Yeah, so right now, if you have residents living in your facility, they have to be notified of these changes. You don't have to rewrite your lease agreement. I checked this with Steve Cox. You can do an addendum to your lease agreement. You can have them look at the residents' rights, and you can have them, you can have them updated with the right to, you have to get on their face sheet, because everybody has a face sheet that's required in documentation for assisted living assisted living homes. On the face sheet is where the resident lists who they want to be notified in case of a discharge. So you can do that in one form in an addendum, say, our admission and discharge policy has been changed. This is the following reasons why you may be discharged from this facility. You do have the right to challenge the discharge. You have 14 days after we initiate a discharge to challenge it. And then you have to, the other one is, who wants to be, the people that want to be notified. So the face sheet, the lease agreement, and the residence rights is what need to be changed. And based on this presentation, all external service providers have to be on the care plan now. So if you've added external service providers, they have to be in the care plan. So does everybody get that?
Question, Janet.
Yeah.
This is Boyd. So while they are challenging the discharge, does that mean we cannot rent out the room?
Good question.
Yeah, because if we rent out the room and then they challenge it and they win, then how does that work?
That's not in regulation and nobody addressed that because I specifically asked them, I had an 8-bed facility. I said, I'm not holding the bed because they can actually appeal it to the state health department. Then the state health department has some crazy number of days, which I can't find. At one point in time, it was 60 days. They have 60 days to get back to the person on their appeal. So you could go 90 days. We can't afford to leave that room unoccupied. So I'm selling the room. I said, so what do you want me to do if they want to come back and I have no rooms? Nobody answered that for me. It's not in regulation. So my answer to you is, I don't know, put them in the garage, I guess. You know, I don't know.
Really that's incredible
written.
that they didn't
It's poorly written.
answer.
It's poorly written. Nobody would answer that. Nobody knew.
And
And
the
it's still wrong.
timing of it.
Mhm.
And the timing, 60 days, are you kidding?
Oh, yeah.
And how much, and I bet that it would be longer than 60 days as well, anyway.
60 days would be pretty fast, I think, for state people to actually do stuff.
Yeah, I agree. I
Pretty
used to work for the
pretty
state.
horrific. Yeah, it's pretty horrific. Yeah, yeah.
Janet, you're doing such a great job. Thank you.
Well, and
dear.
I'm teaching this and I did, here, let me get out of this and see if I can get into, I can send this to Vern. I don't know how he can, send it out to someone else, but let me show you another document that I had that has it very well spelled out. And it's probably over what we can do tonight, but it's pretty awful.
I'm really loving being here. I'm loving hearing all this.
Oh my God,
It's so
it's so
interesting.
bad. It's so bad, Audrey. It's so bad. Okay.
Mm.
Here's what I had to do because it was so hard to teach it to people just based on the PowerPoint because we said, what if this, what if this, what if this? So I went through and rewrote all the regs into one piece of paper. Here it is. First of all, it's in the administrator's duties right now that you're responsible for this. You must designate a person in charge of dealing with discharges. Changes to your move-in document. So this is the only way I could get my brain around it. Reasons that the assisted living could pursue an involuntary discharge of a resident. That's in your resident agreement. Your face sheet is changed to put the contacts in there. Your discharge notice. This is all the information about the discharge notice and who it goes to. The written notice. This is really literally copy and pasted out of the regs because they're written so poorly. I didn't want somebody to say I wrote this. It has to go to the resident's legal representative, any relative or any other person that's designated to receive the notice of discharge, and it's listed on the face sheet. And this is part 18.9 is what lists that. Written notice of involuntary discharge, explanation. This was in the PowerPoint. The supporting documents was in the in the PowerPoint. Involuntary discharge initiated. This is it, you know, yeah. Do you have to issue a written discharge when you cannot accept someone back from the hospital or rehab? Yes, here's the regulation. In the event a resident is transferred to another healthcare facility for additional care, the assisted living resident shall arrange to evaluate the resident prior to readmission or discharge, and the resident in accordance with the discharge procedure listed below. The assisted living residents shall provide written notice of any discharge. That includes somebody in a different health. Audrey, you read regs, that says it, doesn't it? It doesn't say it directly, but indirectly it says if you discharge them to a healthcare facility, you still have to provide them a discharge notice.
So Janet,
Yes.
the assessment part, when they're in a hospital or a rehab center, we always go in and do the assessment in person.
Yep.
But now, are you saying that assessment, if we're not going to be taking them back, has to have a doctor's assessment?
Yep. It has to have a medical professional's assessment.
Okay.
Yep. So you got to get, so if you don't take them back, because they're a 2-person transfer, then PT has to give you a notice that they're a 2-person transfer. I don't know how healthcare professionals are going to feel about this liability. I don't think a family doctor is going to want to write this. I don't, because, you know, what if they're not in the hospital? What if they've developed, what if they have to have a catheter right now and they want you to hire someone to do the catheter? And you're like, no, I'm not doing that. And then the doctor said, well, then you got to get a doctor's note or doctor's stuff that says, yes, they require a catheter. That's why I'm discharging. The doctor said, yes, to have a catheter. Yeah. Some of those are black and white, but some are not. The one that's going to be hard is the fall risk. Because it's kind of, sometimes they're a fall risk, sometimes they're not. Yeah. Yeah. So this, I had to rewrite it into this to train people. Yeah. statements. Here's the conveying the information within 14 days. The grievance within 5 days, and we went an oral explanation. Somebody can give you an oral. If your staff, Audrey, if you need this, you can email me and I'll give you this. If your staff get an oral, they better come to you right away and you better write it down. And you better go talk to that resident. Yeah, because they have filed a challenge orally. That's the dumbest thing I ever heard. You know, we don't get to do any oral information because if it's not documented, it didn't happen in assisted living. So you better do that. If the resident if the resident or person filing the grievance is dissatisfied with the response you gave them, then they have a right to appeal it to the executive director of the Colorado Department of Health. And you know what? This is a typo. I thought it was mine. This is why I copied it right out of the regs, or their designee. Brian, who is the designee for the state health department? Does anybody know who the designee is? This is in regulation. I thought it was my typo.
That's clearly just some oddity that got left over in there. And there's,
Yep.
they might, if it's something that's already in more complicated legal matters, that designee might be the Attorney General's office.
Oh, maybe. Okay. Maybe there's a reason for that. I thought it was a typo. Here's where Steve Cox, because I wrote him, I said, we're sending everybody to you because you guys didn't outline it. He said, oh, no, here it is. CDPHE_legislative services. That's where if the family challenges the discharge, that's where it goes. The challenge discharge. Your discharge notice doesn't go to the state. The challenge goes to the state. And if either party is unhappy with the results of the appeal, as found in Part 9, Policies and Procedures, if the resident or the individual filing the grievance or the assisted living resident is dissatisfied with the findings of the department related to the appeal, they may request a hearing to be conducted by the department pursuant to this regulation. So there's lots of steps. So here's your steps right here. Step 1, issue the 30-day notice. Step 2, the resident or representatives may challenge the discharge with either written or oral communication within 14 days. The facility needs to respond to the challenge within 5 days. The resident or representatives can appeal to the state health department. If either the facility or the resident is unhappy with the decision made by the department, they can request a hearing. That's the 5 steps. And to the gentleman that wanted to know what to do with the room, sorry, I don't have an answer for you. It's not a great option for us. Yeah. Fran's like, oh my God, what am I going to do? Huh? Yeah. So because in the interest of time, we have to go on to the rest of it, which is your fines, which is also not great. Okay, this doesn't change like I think it should be. Okay. Yep, there we go.
So Janet, in my case, the resident is really is violent, and like I said, she hit the other person 3 times in one day.
Yeah.
And I gave them the notice, but the son appealed verbally, and we talked. And they can't find him and find another place, so she's still in my place. But the representative, the PO of the other resident wanted to press charge and don't want it to stay there. So I'm in a place where I don't know what to do.
You know what's probably going to happen? You're going to be stuck with the nasty man, and the nice little lady's going to move out. That's what's going to happen to your friend. I wouldn't keep my mother there next to that guy. Yeah, you have to explain to the family that's mad that these are regulations now. Tell them to call the state health department. Here's your fines. Fines have been increased. Level C is between 100 and 5,000, depending on what the surveyor thinks it should be, I guess. Somebody has to decide this number. It's not written down how they decide what this number is. That's what they put in regs. Level D is in between 500 and 7,500, or 5,000 and 7,500. And level E, 7,500. Level E is between 1,000 and 10,000. Level E is what we know is an immediate jeopardy for each violation or ongoing pattern of egregious violation resulting in serious injury or death by a resident. Okay, now I need to bump. This is in a different section of the regs. So now I need to bump it up against what we're really talking about. Oh man, how am I? Okay, level A. We have 5 levels of deficiency. Level A is an isolated potential for harm of 1 or more residents. That's a potential for harm. So we're not worried about that. That's something that could happen. Level B is a pattern of potential harm for 1 or more. This is for 1 resident. I'm sorry, I have a typo in it. This is for more than 1 this is for 1 resident, and pattern of potential. I'm sorry, this is an isolated potential for 1 or more resident. This is a pattern of potential harm for 1 or more residents. So 1 is a potential, 1 is an isolated, 1's a pattern. Level C is an isolated actual harm affecting 1 or more residents. This is a med error. You've caused actual harm, and I saw it tagged as a level C with a $1,000 fine for not following a physician's order. So that's actual harm to a resident because the physician had written an order for a Lasix and the facility did not have it in the building for 10 days, and the state wrote a level C deficiency because they put that person at harm and they charged them $1,000. Level D is a pattern of actual harm. So med errors to more than 1 person is a pattern of actual harm. And those are $500 to $7,500 per violation.
Our staff could cost us a lot of money
Yeah,
because they're screwing
they're
around.
fired if they do.
Well,
We,
good luck
we'll
finding new people. We're hiring anybody that breathes right now. Did you guys not know that? Level E is immediate jeopardy. That's actual or potential harm for serious injury or harm for 1 or more residents. That's $1,000 to $10,000. So this is kind of scary right here because the state won't tell us what typical violations will cost us. Steve says, oh, it depends on how many times they did it. Oh, it depends on how their survey was last time. Oh, it depends on what we found when we got there. Oh, it depends on how well the rest of the building's being run. He's got a million reasons why it depends. So this is the other scary part about this. This is in regulation. Before, when you had a $2,000 limit, you probably not want to get some legal advice. I'm going to give a plug for Brian here. If I'm looking at $10,000 per violation, oh yeah, I'm calling Brian. What do you think, Brian? You're going to be busy, huh?
I think there's a lot of things here with this discharge that can be challenged long
Yeah.
before you actually have to worry about getting to the level E jeopardy. Although a lot of reasons people are going to be discharging are because the resident is a level E actual or potential for serious injury. So
Yeah, this is Fran's resident right there. Yep. Yeah, so in a nutshell, so now we know the game. So you need to allow visitation during a pandemic. You need to do your dementia training. All administrators who have the 30-hour certificate do 10 more hours. That's not hard. Challenging and discharge. You need to have a plan in place and think this through before it happens. You need to improve your documentation. You need to get staff well trained. And a solid pre-assessment form will be very important for you. You have to also remember, not every resident is going to challenge the discharge. It sounds worse probably than it is. They're probably not. Have good relationships with your families. Families don't tend to want to get all gnarly with people they like. So if you keep them well informed all the way, then maybe they're not going to challenge the discharge.
I think that's the best. I think that's the best thing to do is just
Yeah,
to keep
you're good.
keep them in the loop and have open communication and everything that is going on. Yeah.
With the increase in fines, the state says they'll work with providers. They're most concerned with facilities that have a pattern of non-compliance. They say they will consider the size of the residence as well as the past history of compliance with your building. Tighten up your pre-assessment. Plan to have deficiency-free surveys. A pattern of we'll fix it when the surveyors find it is not a good strategy. I know some places that are doing that. That's not proactive. Plan to be proactive, not reactive. Find things that you know are not compliant. You know that you have care plans that are expired. You know you're keeping residents at fault a lot. You know you have incident reports that are missing information. You know you should be doing behavior tracking. Fran, you should have done behavior tracking like in January on that guy probably. Because this is when they get to that state that he is now, unless he's a new resident, there was probably some telltale signs. And you probably thought, well, he's new, he'll get adjusted. Right when somebody moves into secured dementia care, I'm documenting right from day one. I'm documenting. I'm no longer saying, well, he's just getting adjusted. Let's give him a little bit of time. I'm documenting day one. Organize your time as an administrator to look for compliance issues. That is doing mock surveys. You can also attend some meetings from the association. We are doing trainings like you can't believe on labor law compliance. We did several on this. We did part 1 and part 2 of this problem. So update your paperwork. We went through that, dementia. Train your interim administrator so they know what they're doing in the event that you're gone. Involuntary discharge, you have to designate somebody. We kind of went over that. Resident face sheet, we went over that. Residents' rights, these are the ones that have to be included. Right to designate the individuals to be notified in case of emergency or involuntary discharge. This is on your residents' rights. You know how to write the residents' rights, they're right in the regs, right? You just copy and paste them and realign them. The right to visitation in compliance with the facilities policy is set in part 1. So there you go. Care plans, you have to include your external service providers and your visitation policies. Best practice, make sure your care plan reflects the actual needs to the residents. This could help you in the involuntary discharge process. If somebody left on Friday in a walker and they came back in a wheelchair, who updated the care plan? Because the ombudsman's coming in and saying, well, your care plan says he's in a walker. Policies and procedures you have to update. So this was one. Oh, during Sherry Bonham was at the hearing, and she was able to get us a 999 educational tag. So if you're working on getting these things updated in your paperwork, if you can show the state health department that you're working on them, then they may give you a pass on that and give you a 999 tag. 999 tag is an educational tag. So you need to do something. Even if you just write a quick rough draft and say, here's my rough draft, they'll take that. All right, so that's the end. So that's the down and dirty. It's kind of a lot to digest, isn't it? But oh wow, like Vern says, let them, have a presentation that they can, like they're drinking out of a fire hydrant, and then they'll need you.
Thank you, Janet. You are awesome. Thank you.
Yeah, so if you guys, Vern, I can send you that one page that,
Okay.
on the
Yeah.
involuntary is so hard to understand. And so then and then you're flipping all over the regs because it's everywhere. So I just wrote it down on the sheet. Here it is. You can have it. And I have a summary of the bills that were passed. So.
Janet, I had a quick question.
Yeah.
I had attended the collaboration in aging at the convention center a few months back. And what I was told, I got a certificate for attending a few of the things there for 6 hours. So I've tried to reach out to several people to see if that 6 hours is valid, and how do I do the 4 hours? And so I'm getting nowhere at all. I spoke with Nicole from Wildflower, and she was like, I don't know either. Do you have any update on that?
That was a mess.
That's just looking like
that was a mess. That was a mess. You still have additional 4 hours you have to take.
Yeah.
Yeah. Did you get your certificate from CALA on those?
I did.
Okay, so you have 6 hours. Yeah. All you need is 4.
Just 4.
You know what? Let me find out, because I bet because that's what we gave at that conference, wasn't it? Is 6?
Yes.
I bet you have a lot of people that are still needing 4. You know what? Let me approach CALA. Well, I don't need to approach them, not to brag, but I'm the president of CALA. Ta-da. I wrote it by default. No, I didn't. Anyway, let me approach the educational team about that, because if you're out there, Mary, there's probably a lot of other ones that are out there.
I'm pretty sure. So yeah, like I said, I reached out to other people, and they're like, I'm not sure where we go from here. So I'm like,
let me present that to Cal, and maybe Jess will organize a 4-hour supplementary training for you guys, because you're not the only one, because they have a haphazard system of trying to figure out who was supposed to get the certificate, who wasn't, and it was all over the board, yeah. So let me find out. Maybe we can put together a little 4-hour class that's 2 days by Zoom or something. I don't know. Yeah.
That would be great. Okay, and then so just keep in touch with you and kind of see what we come up with on.
Yeah.
on
Did
that.
you get my email? Did you get my email?
I did.
Okay. Yeah. So you can contact me by email and I'll get you that answer, but I'll try. I don't have your email, Mary. So, yeah. So if you want to email me, then I can get back with that answer. Yeah. Yeah.
Thank you so much. I do appreciate that.
We
'cause I
need to solve
been-
that problem. I completely forgot.
Yeah.
Yeah, I knew that
Yes,
was
and
hanging out there.
I'm holding certificate and I'm like, where do I get the other 4 at? You know, so that's great.
Well, and
Thank you.
originally we were gonna do the 10 hours by modules. And then you have to send out a different Zoom link because some people are in the wrong Zoom, and it was just like, okay, let me start with the 10-hour and do that first. Because
Thank you.
yeah, Dennis Scott and his partner said, we only need 4, you know, and so then he's like, forget it, I'm just gonna take the 10, you know, so. Yeah, but let me address that, because if you're out there, there's a bunch of other people, because we had a lot of people at that conference. Yeah.
Yes, yes. Well, thank you so much. I appreciate that.
Okay, any other questions? I think now you do a needs, wants, and things like that, don't you, Bert?
Yeah, does anybody have haves and wants that they want to present to the group? Is there anything you have you want to put out there?
I have a want.
Okay.
I want to change the regs. I don't want these. Can I have a don't want? I don't want these regs.
I don't know if we can help you much with that, but
You know what? We did find out you cannot file a bill to change the regs until they've been in force for a year. So I did find that out, because I was trying to figure out, okay, how can we file a bill to change these? And you can't do that until they're already in effect. We are tracking how dangerous this is, especially for the care needs you cannot meet and the behaviors. So if anybody has that problem, you need to contact CALA, because we are collecting that information. It's private information and the state is not going to give that to us. So we're trying to actively keep in touch with our partners to say, if you've had problems, then we need to know about it, because we have documented the gentleman that gave a family a respite stay and they challenged the discharge. And that's not supposed to happen. Yeah.
wow. Okay, anybody else?
Can we get access to these slides, Janet?
You know what, I will give you I'll send Vern the document. I don't give the PowerPoint because then people just change the name on it and then they steal it. You can do your own PowerPoint if you want, but I have it in a written form that I'll give you the information for that. So I'll email it to Vern. It's not the actual PowerPoint, but it's pretty much a document that went over what we did. And I'll send the involuntary discharge stuff to Vern, and I don't know how he's going to get it to you, but you can contact Vern.
Probably what I'll do, because I think this is so important, is once we have this recording uploaded to our website, I'll send out that link along with your doc that you sent.
Okay.
To the same email that I sent everybody the invitation.
Yeah. Yeah.
Because the people that weren't here need to hear this too.
Well, and it's complicated. Look how many days are in that stupid involuntary discharge. Wait, do I have a 5? And you know what? It's really creepy, because if you go back to it, some are calendar days and some are business days, and it's in regs like that. So it's really creepy. Yeah. You should have a new copy of the regs. They are up. So you need a new copy of the 2024 regs. In 2018, we had 44 pages worth of regs. And then in 2018, which actually got released in 2020, they went to 70. And now they're 80. So
they didn't change the link any, did they?
No, but you know what? If you need them, Vern, I'll send them to you. Yeah.
I'm just going to check the site and see if our link still goes to it.
Yeah.
If you use Google to search it, you'll go with the old ones.
Nice of them to update that somehow or another. Yeah.
Where do they have the date on these?
It's right on the face page.
You can also go to the Secretary of State's page, and all of the regulations and laws are there. So, and whatever they post there will be the most current ones.
Okay, yeah, we're going to the old ones.
Yours is still the old ones.
Yeah, this is 2020.
Oh, that's the 2021 regs. Yeah, I don't know how to get up to the beginning of these. Oh.
All right, we'll find the new regs and update this link.
Yeah, because they actually say right here on the very front page, Vern, it's look at all those. Oh, we're 81 pages, guys. I missed a page, darn. I don't know how to go back to the first thing. Yeah, so anyway, Vern can get that to you, but it does stay on the very front page what the regs are for. They are November 15th of 2023.
Can you shoot me that link too?
I was going to do that because I saw your website. I didn't want to throw you under the bus in the beginning. Vern, it says June.
Thank you.
I was already going to do that for you. Yeah, we got a lot going on. You got a lot going on with all your closings, so we'll try to keep you compliant too, Vern.
Thank you.
Yeah. Okay, well, contact me if you need me. I put my stuff in the website. I'll be happy to, lead you in the right direction. Not that I have all the answers, but we can I think you need a friend in the business that you can both read the regs with and go, what does this mean?
And just to remind everybody in the chat screen down below where you put your information, there's 3 little dots at the bottom. You see the smiley face and then file and screenshot, and then the 3 dots are on the right side. And if you click on that, you can see save chat, and that will allow you to save everything that everybody put in this chat as a text file. So that's how you can connect with the people you met tonight. Janet, thanks again. That was a wonderful presentation.
Yeah, it's always
much
nice
good
to see
information.
Auburn's people and so I don't know if Vern, you know what we probably do? We need to link the CALA trainings to your site because we do them on Tuesdays. I don't know how we ever would do that, but I don't know.
I think
It's
that's
out there.
very
It's
good.
above my pay grade though. Peter can do that for us.
Yeah,
Peter,
Peter
that's
can.
his pay grade. Peter used to be our executive director. Peter has resigned from CALA and we have an association management company now. So there's been some training along the way because Peter knew so much. He was part of CALA for 14 years that when he tried to write it all down, he missed like 2/3 of what he used to do. So now we have to figure it out, you know, like Peter knew that when you hold an event, you eventually close the registration. And I did the 10-hour bridge and I thought I had 18 people in it. And Monday morning I had 26 and 8 people didn't have the Zoom link because nobody closed the registration. I was like horrified that people didn't have that. So yeah. All righty, guys.
Thank you, Janet. Thanks
All right.
everybody for
Thank
attending
you. Okay.
tonight.
Thanks.
Bye-bye.
All righty, guys.
And
We'll see you soon.
you.
Okay.
Thanks so much.
Oh yeah, sure.
Bye-bye.
Bye-bye.
Thank you, Vern.
You're welcome.